Hey there, it's Wendy Hernandez with Command the Courtroom. If you are even thinking about filing a petition for contempt of court against your ex, you're going to want to watch this video. I'm going to talk to you about some of the most commonly made mistakes when it comes to filing petitions for contempt of court. Stay tuned. I'm Wendy Hernandez. I'm a Phoenix family law attorney, and I'm also the creator of Command the Courtroom. I started creating the Command the Courtroom videos about 7-8 years ago because I really wanted to help people who didn't have the resources to get lawyers and who needed help in their child custody cases. I got sick of seeing people crash and burn in the courtroom, get paralyzed by fear in the courtroom because they didn't have the knowledge or understanding of child custody law that they needed to have. So as a result, the YouTube channel was born. Now there's hundreds of videos on the Command the Courtroom YouTube channel. Check them all out. If you like them, give them a thumbs up. Don't forget, hit subscribe if you want to get notifications of when a new video is released. And also, don't forget to download that best interest checklist, which contains all of the factors your court is going to consider in making decisions about your child custody case. All right, so let's get on to the issue of petitions for contempt of court. And I have to be honest, I don't file a lot of petitions for contempt of court. They are few and far in between in my practice. A lot of times people do want to file them. In many cases, they want to file them for a single instance of somebody denying them parenting time, or a single instance of somebody not allowing them to have a phone call with their child. In many of those cases, what I tell my clients or potential clients to do is to kind of save up those individual incidences so we can put all of them in one big petition instead of filing petition after petition after petition for each single incident. As a result, I think that's part of the reason why I don't file them that often. But I had a recent case where we had tons of occurrences of violations of orders that were in effect, a violation of contact orders between my client and the child, violation of parenting time orders between my client and the child. And thankfully, we looked at the rules, we double-checked the rules, and all of our petitions were up to snuff. The other side, however, in that case, filed a petition for contempt of court because they alleged that my client was in contempt of court for not paying child support. Well, I'm going to save you most of the details, but what I will tell you is the first mistake that the other party made, actually was the other attorney in this case, was citing to the wrong order. So number one, so your petition for contempt of court does not fail. You need to make sure that you are actually citing to the right order, to the most current order in your case. In the case that I just handled, the attorney who filed the petition for contempt actually filed for contempt under an order that was not the most recent order. It was actually a temporary order, and as a result, it was not the valid order to be filing a petition for contempt of court under. However, nobody caught this, not even the judge, until after the trial had concluded and after the judge had issued a ruling. And when everybody caught it, now we are trying to correct the error. So mistake number one, make sure you have the right order. Make sure you cite to the right order. Number two is make sure that the order that you're trying to get your ex on contempt for is actually a clear order. So in this particular case, while my client and I had tons of allegations of contempt on different things, with respect to one thing, the order was pretty ambiguous. It was pretty unclear. And I had doubts about whether the court could find the other side in contempt because I thought that my client and I were going to have problems proving that the other party was in contempt for a certain thing because the order with respect to that thing was susceptible to more than one interpretation. And we tried, but also I was right. And the court didn't find that prior order with respect to one certain thing was clear. And as a result, he didn't find that the other party was in contempt, although he did find the other party in contempt as to a whole bunch of other things. So before you spend your time and your money prosecuting contempt, especially if you're just doing it on one order, make sure that order is crystal clear. Make sure that it is as close to a slam dunk as you can get. Make sure that that order that you are seeking to have the other person held in contempt for is not susceptible to more than one interpretation. Okay, so the next problem that I often see people have when it comes to contempt in Arizona especially, is they don't follow the rules of procedure. So as for everything, when you're filing any kind of petition or any kind of motion, there are rules that are in place. You have to look at your rules of procedure, whether they're rules of civil procedure or rules of family procedure. Prior to sending that motion down to the courthouse or to the clerk of the court, make sure you've complied with the rules. And what I see and what I saw in this case that I was just talking about is the other attorney did not follow the rules. The other attorney did not cite to the proper order that he was seeking to have my client held in contempt for. And I think that was part of the problem. And that's what led to the mistake. He didn't cite to the correct order. He did not quote the language from that prior order. He did not attach a copy of the order. And the rule doesn't require all of those, but it requires at least one of those or some of those, and he didn't do any of those. Number two is, in that case, the other attorney did not have his client sign a sworn statement saying that everything was true and correct. So this may or may not be the case in your jurisdiction, but check your rules to see if you're the one filing a petition for contempt of court, whether or not you have to sign in front of a notary to verify that everything is true and correct. And if you are required to do that, then by goodness gracious, you need to do it. The other mistake the other attorney made in this case was trying to have me accept service on behalf of my client of the petition for contempt that his client had filed. And according to the rules in Arizona, I cannot accept service of a petition for contempt on behalf of my client. My client has to be personally served with that petition. So in this particular case, I advised the other attorney that I could not accept service. And I also advised that my client would accept service. I just needed to get my client into the office to sign. So these may not be the same rules in your jurisdiction. And as I say in almost every one of these videos, you have to be clear on the rules in your jurisdiction because they could differ from state to state. They could differ from Arizona, which is the only state that I'm licensed in. And many of the examples that I talk about in my videos are based on Arizona law. So check the rules, check the rules, check the rules, and follow the rules to the T. If you have questions about the rules, then ask somebody who knows about the rules. Have a consultation with an attorney. Go down to the law library and talk to somebody who knows. Meet with a law student. Talk with a legal paraprofessional. Understand what you're doing before you do it. Because if you don't follow the rules, actually, and you force the other side to jump through all kinds of hoops because you didn't follow the rules, then potentially you could be ordered to pay the other party's attorney's fees and costs for making them jump through the hoops and for you not following the rules. And that's the last thing you want to do, is pay more money, more time, have more stress, and have more anxiety because you did not follow the rules. Follow the rules. So the next problem that I frequently see people have is they can't prove their contempt. And yes, I have said in past videos that testimony is absolutely evidence. You can go into court and you can talk about what the other side did or did not do, and they can do the same thing. And in that situation, it turns into a he said, she said, or he said, or she said, she said. That's a tongue twister. Anyways, it's better if you have documentation. If you don't have documentation, you have to do what you can with testimony. But if you're saying the other side, for example, has not paid child support, then how about getting a printout showing that child support hasn't been paid? How about getting an arrearage calculation? How about showing a bank account that doesn't show any deposits for child support? How about getting anything that shows the absence of child support being paid? That's number one. In other cases, I have clients want to prosecute for contempt when they say the other side has violated a court's parenting time order or communication order with the children. So in those cases, like say my client is supposed to have telephone time with the children every Monday, Wednesday, and Friday at 6 p.m. In that case, we submit telephone logs where my client tried to call the other side or call the children showing that there was no answer. Or we show my client's telephone logs that don't show a call coming from the other side or the children. If parenting time hasn't happened as it was supposed to happen, for example, in this case that I have been talking about throughout this video, it was a long distance parenting time plan. And my client gave notice of the time he was going to exercise with the child. And my client also provided the plane itinerary, and my client also provided the tickets to the other side. And we had proof of that because my client used an application called Our Family Wizard. And we also attached proof that the other side never even bothered to open his messages in Our Family Wizard. And so when the child did not show up in Arizona when he was supposed to, it was easy to prove why that had not happened, because the other side never even bothered to read my client's messages to her in our family wizard. So, you may have a different contempt issue, but you really have to think about and brainstorm about the evidence that's going to support your contempt allegations. Get a hold of it and be ready to present it when the time comes at your trial. All right, so this is the final point I'm going to make on contempt, and that is about attorney's fees and costs. And by the way, if you haven't watched this video on attorney's fees and costs, then go ahead and check that out now. And also as a reminder, if you haven't downloaded the best interest checklist, download it. Okay, so a lot of times when I'm helping a client with a petition for contempt, my client wants attorney's fees because my attorney says, hey, the court order is clear. The other side is not following the court order. As a result, I'm being deprived of either child support or parenting time or telephone time, and I shouldn't have had to bring this contempt action. And if I prevail on this contempt action, then I want the other side to pay for your attorney's fees and costs, Wendy. So that is all fine and good, except if you don't ask for attorney's fees and costs in your petition for contempt, then the court may not allow you to ask for it down the roads. Technically, anything that you asked for at the time of a hearing or at the time of trial needs to have been pled in the original petition or in the original motion. So always, if you're going to ask for something, then you need to ask for it right at the get-go, because the other side needs to have notice of what you're asking for so they can prepare your defenses. If you don't ask for your attorney's fees, you could go through a months or years long proceeding for contempt, have a hearing, spend thousands of dollars, if not tens of thousands of dollars, get to the end of it and win. But if you haven't asked for attorney's fees and costs, you may not get them. Okay, so that's going to do it for this little video on contempt of court. Again, if you like it, give me a thumbs up. If there's any videos or topics that you'd like to see covered, leave me a comment in the comments below. And until next time, remember to keep on trucking and get out there and command the courtroom. Thanks for watching.